Navigating a legal issue within your own family, well, it can feel like trying to find your way through a storm. But what if I told you there's a calmer, more direct route? Today, we're going to demystify a process designed to be exactly that: court-annexed family mediation here in the Philippines. So, how does it actually work? And could it be the right path for you? Let's figure it out. Look, if you've ever been in the middle of a family dispute that has to go to court, you know the feeling, the emotional drain, the financial stress, just how complicated it all is. It is completely overwhelming. It's a situation that has so many people desperate to find a better way to move forward. And that's really where you come to a fork in the road. On one side, you've got the traditional court battle, which, let's be honest, can be long, expensive, and often feels like a fight. But there's another path. One that was purpose-built for family matters: mediation. This path isn't about winning an argument. It's about finding an agreement that everyone can live with. So let's dive into this alternative path. Now, this isn't some informal suggestion or a new idea. This is a formal program actually mandated by the Supreme Court of the Philippines. It was specifically created to bring a much more streamlined and, frankly, peaceful approach to handling family cases. So what is it, really? Well, court-annexed family mediation means that as soon as a family case is filed, the court itself points you toward a formal mediation process. The whole goal is to help you and the other party find common ground and reach a friendly settlement, all with the help of a neutral guide, so you can avoid a long, drawn-out trial. And you might be asking, why even create this program? Well, it's really built on three core benefits. It's designed to be less expensive, saving you from those crazy legal fees. It's way simpler procedurally than trying to navigate complex court rules. And a big one, it's meant to be much, much faster than waiting for a trial date. But, and this is a big but, is this option available for every single situation? Not exactly. The rules are actually very specific about which cases can and cannot be mediated. So let's get clear on what's covered and, maybe even more importantly, what is absolutely off the table. Okay, so this process is perfect for some of the most common family disputes. We're talking about things like financial support, child custody, visitation rights, how to divide property, and even the guardianship of kids. These are all things that can be discussed in mediation. These are the areas where finding a compromise can lead to a much better, more stable outcome for everybody. However, the law draws a very, very firm line here. There are some serious cases that are strictly forbidden from mediation. This is totally non-negotiable. It includes any situation that involves violence or abuse under laws like the Anti-Violence Against Women and Children Act. Also, you can't mediate fundamental legal questions, like whether a marriage is valid or not. Those critical issues must be decided by a judge. No exceptions. All right, so let's say your case is eligible and you're ready to go. What does this journey actually look and feel like? Let's walk through it, step by step. First things first, you'll get acquainted with the Philippine Mediation Center Unit, or the PMC. This is the official office designated by the court where all the mediation happens. It's usually located right inside or very close to the courthouse, which makes it a really smooth part of the whole process. This is where you'll meet your mediator. So here's a quick bird's-eye view of the whole pathway. It all kicks off when a judge officially refers your case to mediation. From that point, you and the other party will select a mediator you both agree on. The heart of the process is the mediation meetings themselves, and it all wraps up when the mediator sends a final report back to the court, saying whether you reached an agreement or not. So what really happens when you're in that room? Well, it usually starts with everyone together in what's called a joint conference. The mediator will explain the ground rules and try to find some common ground to start from. Now, if things get a little stuck, the mediator might hold separate, private meetings with each of you. Those are called caucuses. It's a chance to better understand what each person needs before bringing you back together. Now, probably one of the most important principles of this entire process is confidentiality. The official rules say it plain and simple. Mediation proceedings and all incidents thereto must be kept strictly confidential. That's not just a guideline, it is the absolute bedrock of mediation. It's what creates a safe space for real, honest talk. So what does strictly confidential actually mean for you? It means that anything you say, any offer you make, any admission you might let slip during mediation, none of it can be used as evidence against you if your case ends up going to trial later. It's a powerful protection that lets you explore all sorts of solutions freely without having to be afraid. The person right at the center of this journey is, of course, the mediator. But you need to know, they aren't just some random person helping you talk.
They are official officers of the court, and they are bound by a very strict code of ethics. Understanding their role is absolutely key to trusting the whole process.
To really get it, it is so important to understand the difference between a mediator and a judge. A judge's job is to listen to arguments and then impose a decision on you. A mediator, on the other hand, does not decide who's right or who's wrong. Their job is to help you and the other person create your own agreement. They guide the conversation, they don't rule on the outcome. And to make sure everything is fair, mediators have to operate within these really strict ethical guardrails. They have to be completely impartial, no favoritism at all. They need to be competent, meaning they know their stuff about mediation and the law. And, this is a huge one, they have a duty to tell you about any potential conflict of interest they might have. So, when you think about the mediator, think of them as the guardian of the process. Their entire job is to create a balanced, safe environment where you feel empowered to find a solution. The final decision is, and always will be, yours to make freely and fairly. So after all the talking is done, the journey reaches its end. But what does that destination actually look like? Well, there are really two possible outcomes, and each one leads down a very different path next.
Think of it like two forks in the road. Path 1, you succeed and reach what's called a compromise agreement. That document gets sent to the judge, and it becomes the foundation for a final court judgment. That's a win. Path 2, you just can't find an agreement. In that case, the mediator files a certificate of failed mediation, and your case gets sent right back to the court to continue on the traditional path toward a trial.
Ultimately, this whole process really challenges how we think about solving problems. We're so often taught to think in terms of winning and losing, of arguments and battles. But maybe, just maybe, a guided, confidential conversation could be more powerful, and in the end, more healing than a fight in a courtroom. That's really the question at the very heart of mediation.